In part one, you learned that a lot of thought must go into any decision to add someone to the title of property. It may not be wise to add a spouse who has judgments or liens, as they will attach to the property. Likewise, adding a family member or significant other who has not filed their taxes in years can also present a problem. A better option would be to draft a simple will to serve as your voice regarding what you want to happen to your property and other assets. In part two, we're going to talk about blended families and how to protect the interests of your children, your spouse's children, and the children that you share jointly. Each state has succession laws. However, they don't supersede the rights of those on the title to your property. Let's continue our conversation with Kim Hughes, a real estate attorney with KG Hughes Associates. Well, you know where it gets a little sticky is when you have a blended family, and I think we need to talk to this because there's so many blended families.
Sure.
And I've had an opportunity to talk to a couple of them, and a couple of people, and they're not sure how to handle it. You know, you may have a situation where the wife has had 2 children prior to getting married to the gentleman. He has a couple of children, and they have children together.
Right.
So when we're talking about what happens to your stuff, what happens to your possessions, your assets after you were gone, that was one question that I got. You know, when we have, as a result of COVID, there was a lot of unexpected death, and people did not have time to plan.
Yeah.
And whereas one person thought for sure they were going to inherit their mother's property, which was in another state, it wound up getting held up. And it's like, where do we go from there?
Right.
So how does this whole thing play in when there's a blended family? I know that each state has a succession law, how things are passed down. But how does things come into play, or what advice would you give to somebody so that they know how to make sure the ones they want to inherit the property or assets? Because like I said, in the case of real estate, it's already sort of predetermined by this, how it's titled, right?
Well, when it comes, yes, that's when we were talking about tenants in common versus joint tenancy. Okay. So let me just start with there briefly, where if property, we're talking about real estate, is titled where there's joint tenancy with rights of survivorship. So let's just use an example. Husband and wife, they buy a house together. They want the warranty deed to be titled that way, joint tenancy with rights of survivorship. If either of them passed, even without a will, the other one is the sole owner of the property, okay?
Okay.
So what that means, bringing in your scenario about a blended family situation, that if the one who is deceased had children outside of that marriage, then that means they would not get any ownership or any share of that property automatically without the spouse being willing to do something. Now, that's not necessarily a bad thing. The question is that what you would have wanted to happen? You know what I mean? So if you, the person who is deceased in a blended family situation, want to make sure that your children outside of that marriage are thought of, and this is all without a will now, because with a will, you can spell all this out. That's why it's very important to have a will in place so that things aren't relied just on the succession laws of any given state.
But wait a minute, will that will supersede title?
No, well, in that case, well, it will if the will says that I want a portion of my any other assets. I mean, for example, in the case of a property, if it's joint tenancy with rights of survivorship, no, it will not. Okay. But I'm bringing that up because a will says that if something happens to me, I want a portion or a share. So the executor of that estate, even though, let me kind of break it down like this. The owner of the property, they would have the right to sell without asking or requesting anything else from any heirs. Okay.
Okay.
But if the will says whoever's the executor of the estate, they have to honor the will of that person who is deceased. Does that make sense?
It does.
So joint tenancy with rights or survivorship, without a will, it tells you exactly what will happen to that property. But if you have a will that says a certain percentage is going to go, or of my share, I want to go to my child, that will supersede the joint tenancy laws. It just means that someone has a right to do whatever they want to with the property. But when you have a will in place, assuming everyone can find the will, because that's the other issue. I've had situations where people try to say there's no will, and all of a sudden a will shows up. So that's the thing, unless a will is recorded in the county records to be able, when title is run on a property, you may not know that one exists.
And especially because you're not required to file a will.
Correct. You're not required, at least here in our state.
Georgia.
Yeah.
Okay, so let me back up, because I want to make it real clear to people. So I just want to give an example to be sure everybody is following along with you. You have a husband and wife. They're in a car accident. And one of them transitions and goes home to be with the Lord. They have a house. And for most heirs, that's one of the main things they're concerned about. They're not concerned about the little pots and pans and that kind of thing. You have a house. You have the property is titled joint tenants with right of survivorship. So in the case of the accident, one person transitions and goes home and be with the Lord. At that point, that house passes on to the surviving spouse. But let's just say a week later, that surviving spouse now transitions. If there is no will, the first spouse who passed, if they had children, really wouldn't inherit the house because it all goes to the surviving spouse.
Correct.
The surviving spouse doesn't have children. However, his next of kin is a brother who they haven't seen in years. He
would be entitled according to
let's break it down. Let's break it down. He get mama's house. Okay, now that's serious.
That's correct.
And that is something that I think people don't understand. All too often when I'm talking to women, particularly who have children, they want to make sure their children are taken care of.
Well, and let me just correct one thing, because the laws of succession state that if the last spouse who deceased, if they have parents who are living, it goes to parents. Yep. And then if there are no parents, then it goes to siblings. But either way, parents can be the same situation.
Wait, Kim. So now listen. I have 2 children. Me and my husband have an accident. I go home to be with the Lord. These are my babies. I've worked hard to make sure my babies have a roof over their head. My grandkids, that I leave something. I leave it an inheritance to my kids. But if the man I'm married to is not their father, I go home and be with the Lord. He passes a week later. He goes home and be with the Lord. My kids are out. Even if I go home to be with the Lord and he lives, my kids are out. They will not be inheriting that house. I'm telling you, you better, well, I don't know. You said a will supersede that, or do you need to stop to think about how it's titled? And that's
we talked about the situation with no will. This is why I'm an advocate. And it's something, and I'm seeing it more since COVID, more requests, particularly in minority communities. We don't talk about this kind of thing. And I'm actually dealing with property now that is tied up because we had several people who died in the line of succession, and now dealing with a situation where there's one of the children's in jail and all of this. So you're dealing with what happens from here. That's what I'm saying. It puts people in a situation where they're stuck. Nobody in several lines of this family had a will. If there was a will in place, you have to look at it. A will is my voice after I'm no longer here. And at least if there's a will, and you have to make sure that whoever is named as executor of that will is somebody that's trustworthy, that you feel will do the right thing, make it available. Because wills can be contested. However, not like a situation where there is no will and people are trying to figure out and go to court and sue somebody because they think property should go to them. So there's always legal rights that people have, but how many people have money in that situation? Usually these situations are people need assets from them, so they're not trying to find an attorney to contest anything. So if you have a will, that's your voice. And if it's properly done, that's why I say don't go out there trying to write something on a napkin, put it in your drawer, seek legal counsel. Prices of wills can vary from any state, but a simple will, at least here in this state, I say can range anywhere, and attorneys can charge whatever they want, but reasonably anywhere from $500 to $800 for a simple will that pretty much your main thing is a house and you want to make sure that gets divided properly, and or bank accounts, so people, even when they don't have property, like the way I do my wills for people, even if they don't have property, but you got bank accounts, you have some assets. But the provisions I put in place is that, any real or personal property. So the property doesn't have to be named in the will. But if you say any real property or personal property that I own at the time of my death, I want to be handled and distributed this way, even if you acquired a property and happen to pass the next day, at least your will has addressed that and confirmed who you want the property to be distributed to or how you want their share to be distributed.
And I think going along with that is your will also allow you to dictate your wishes as it relates to the care of your children.
Absolutely.
And a lot of because some people think, well, if I have the kid, I can control what they have inherited as well. And so that is the other piece. I tell single women all the time, they're like, well, no, I would never want my, their daddy to wind up taking care of our child, having custody after I'm gone. I said, but many times in addition to having the children, they have what the children have gained or what they've inherited, have control.
They can. I say can because depending on the age of the children, if they're minors, you can set up a trust for them, which
No, you go ahead because you're talking about words that a lot of people, a lot of demographic, they don't even understand it. They can't even get to that point of understanding
let me keep it simple like this. Just like you said, within your will, there are provisions and vehicles that you can put in place to address the care of your children if they're minors.
Right.
Okay. And so I think what I want to highlight here is the importance of being able to have that type of simple estate planning vehicle as a start so that you're able to have a voice beyond your death, to make sure that those people and those things that you care about are handled in the way that you would want them to be.
For some people, that's so big, the thought of even writing a will.
I know.
And it's like there's so much thought that has to go into it, and then you have to go to an attorney and you have to pay, and they don't act on that. They realize that it's important, but they don't do it. There are software programs out there like will maker programs. Would you recommend that? That's something that somebody could do right in the privacy of their homes?
As long as they make sure that it's state specific. Okay. So and that's what my concern about people just going online and using whatever, make sure it's state specific because that's how the laws are governed when it comes to estate and probate and inheritance. It's state specific. So that's very critical. I can speak to in Georgia, it's because again, the form of a will is important because it's less likely to be successfully contested. That's why I said some years ago, people, I write something on a napkin and this is how I want things done. But that's easily contestable, But if you have proper form, just like we know, even when we're talking about quitclaim deeds, I don't mean to bring that into this discussion, but the form of a quitclaim deed is going to determine whether or not it's legally valid for the state that you're in. The 2015 Georgia laws changed, so we don't use forms of acknowledgement anymore. It has to be a witness and a notary. where forms of acknowledgement, not for the audience not to confuse, but it's a different format. So if you try to do a form of acknowledgement now in 2022, that quitclaim deed can be contested because it's not a legally valid quitclaim deed. It's important to at least understand that what you're doing will be valid in the state that you're in.
You've mentioned quitclaim deed quite a few times. And if you will, I want you to help people to understand clearly what that is, because I had somebody that called me. There was a person who wanted them to purchase property. It was an investor. And really, I believe it was a scheme, but it was an investor who was trying to find people with good credit who would buy the property. They were going to teach them how to be an investor. And then they said after the person got the property, they would quitclaim the deed to the company. The person didn't even understand what that meant, but they bought the property.
Okay.
And fortunately, before they quitclaimed it, they called me.
Good.
Please explain what a quitclaim deed is.
Now, and let me emphasize too, it's not quick, Q-U-I-C-K, because the people, a lot of times you're hearing things, it's quit, Q-U-I-T. That's a Latin term, has to do in legal, that I don't want them to even worry about that, but I want them to understand the proper name of it. That is a form of transferring that basically says, I'm not sure, and it's not like a warranty deed, which is another form of transfer that we use at closings, okay? What a quitclaim deed says practically is, if I have any interest in this property, so it's not even guaranteeing interest, and I say that's important because I'll tell you a situation I got a phone call with yesterday. If I have an interest in this property that we're conveying, I give it to you. The reason why I say if, that's what it's saying, if I have an interest. I got a call yesterday about someone that an agent was getting ready to list a property. She said that we think would be the seller, bought a property via quitclaim deed. They didn't even use an attorney. It was via quitclaim deed. Come to find out, and the realtor called me and said, I just wanted to make sure that she could even sell this, because when I look on the records, the real estate records, I'm seeing where a woman owned this, and apparently it was the stepson of the woman that came to this lady who's now wanting to sell to say, here, I'll sell you this property and I'll give you a quitclaim. He may not have even had legal valid title to the property. There was no title search done. I don't know how much she gave him, but she gave him something. If he walked away with $2,000, that was more than he had just by signing a piece of paper. And so my point being is that all a quitclaim deed does is saying any interest that I have in this property, if I have any, I convey to you, the person I'm trying to give it to.
Many people have financial questions and they don't know where to get answers. Now you do. We want to be your resource by providing you with educational information in a way you can easily understand from people you can trust. I invite you to send your questions to Ann at askannanything.com. Your questions form the basis of our show. Additionally, we offer live Zoom educational classes on home buying and credit that you will want to take advantage of. Remember, home buying starts with planning. For more information or to register for our course, go to askann.com. Now, if you enjoyed today's show, please click like and submit. I look forward to seeing you next time.